Good morning and good afternoon. This is on behalf of the Rutgers Center for Innovation and Worker Organization and the Center on Law and Social Policy. I would like to welcome you to this webinar. This is the fourth webinar that CLASP and CWO have organized for city, county, and state labor standards enforcement agencies. This is Pranitha Gupta. I'm the Director of Job Quality at CLASP, and my colleague Janice Fine is from CWO is also on, and she'll be talking in just a minute. So far, these webinars have covered retaliation, intake and triage practices, and strategies for effective investigations. Our hope has been to create a forum for agencies to learn from their peers, share strategies, and pool ideas and information.
Next slide.
So I know I just wanted to review how you can ask us a question during the webinar. So you can raise your hand to be unmuted and ask a question verbally. We're asking everyone to hold their questions until the very end. So when we open up the Q&A portion of the conversation, again, you can raise your hand to be unmuted and ask a question verbally, or you can type in your question in the chat function. So just let us know if you have questions along the way. Otherwise, if you can hold your questions until the end, we definitely want to have a robust conversation. So I am going to pass it on to Janice. Thank you.
Hi, everybody. This webinar is meant to help us to spotlight effective strategies for prejudgment enforcement, estimating ability to pay, negotiation, settlement agreements, judgment collection, and compliance monitoring, which we know is a handful. And I'll come back in a second and show you a slide that should be helpful. We're hoping that we can show you kind of the flow of things so it'll be a little bit clearer what we're doing. But for now, can we go to the next slide? I'd like to give you a sense of who's going to be our presenters. Laura Fortman, the former Deputy Administrator of the U.S. Wage and Hour Division, the U.S. Department of Labor. Matt Ciroli, who's with the Department of Industrial Relations, California Labor Commissioner's Office. Sarah Lehrer from the Seattle Office of Labor Standards. Cynthia Mark, Chief of the Fair Labor Division of the Massachusetts Office of the Attorney General. And Pranitha and myself. Next slide, please. We're really excited that we have more than 120 people who have signed up for this webinar. We have people from many state agencies, many city agencies, and this just gives you a sense of many of the advocacy and organizing groups and funders and research organizations that are joining us on the call. So we're really excited. So now let me just say a little bit about the flow. Next slide, please. So the flow of the webinar, the idea is to follow the flow of a typical case. So think of this as the labor standards enforcement version of Schoolhouse Rock, and I won't sing to you. But we're going to start with prejudgment enforcement and estimating the ability to pay. We'll move on from there to negotiations, from there to settlement agreements, from there to judgment collections, and finally to compliance monitoring. And you will see that over the course of this webinar, we'll keep referring back to this slide so that you'll always be able to tell where we are in the conversation, because we know that this is extremely technical. So next, we'll hear from Laura Fortman and then from Matt Ciroli about prejudgment enforcement and estimating ability to pay. Next slide, please. Okay, Laura. Laura, we can't hear you. Can you guys hear me? This is Janice.
I can hear you.
Yeah, I can hear you.
Okay,
This is
Matt.
Cindy, I can hear you.
Okay, if Laura's not there, then maybe we should move on to Matt. Next slide, please.
Great, I can start. Have the slides moved? No, there.
Yeah, this is good.
Great. All right. Okay, thank you, everybody. Thank you, Janice, for putting this together. There's a lot of material, so I'm going to not go too into technical details, but feel free to contact me offline if you have questions. But I'm just going to try to do a sort of broad overview of what I've seen in my experience over the last 12 years trying to deal with judgment enforcement and collections on thousands of low-wage worker cases. And let me start by also saying that my view is somewhat skewed towards low-wage worker cases. So some of this may not apply where you have less shady employers, but we're often dealing with very shady employers. So that means that you have to approach the cases in a certain way, I think. So first, I just wanted to say broadly, because we're talking about collections and judgment enforcement, and I think there's often a lot of mushing together of the two ideas, and it's worth breaking them apart because I think it helps you be a lot more effective in collecting wages for workers. And the difference is really collections is something we're always doing, right? I think we should always think about these cases from the day the worker comes into our agency, honestly, before the worker comes into our agency, as collections cases. That's what they are. We're trying to collect money. That's the end goal. I know there may be other goals sometimes too, like to get a compliance monitoring agreement in place, but from the worker's perspective, it's always a collections case, right? They know they're owed the wages, usually. They don't come to us asking for us to give them a piece of paper that tells them they're owed money. They're not coming to us saying, hey, agency, will you please endorse the fact that I'm owed money? They're saying, agency, will you help me collect this money? So it helps to be focused on that goal from the get-go. Not that, of course, we have to determine that it's a valid claim, but for low-wage worker cases, at least, it's often very clearly a valid claim because it's something like not paying overtime, and it's fairly obvious that it occurred. So judgment enforcement, which we'll talk about at the end, I'm not going to talk about that right now, but just to quickly preview it, because we're going through the life of the case. Judgment enforcement, which a lot of people call collections, or you can call judgment collections, but judgment enforcement is a much narrower idea. That means that if you have a court decision or an agency citation that becomes a court decision using some very specific legal tools to try to take people's money and assets, try to take their stuff to force them to pay because they're refusing to pay. So it's a much narrower idea. So we're starting with the idea of collections, the broad idea of collections. The worker walks into your office and says, hey, help me collect this money that I'm owed. And how do we do that? So we can go to the next slide. So I think, broadly speaking, there are really three ways to collect a debt, and this is true pre-judgment. I'm talking worker walks into your office and says, hey, I think I'm owed money. And if you're thinking about it as a collections case, that means thinking, okay, how do I collect this money? Assuming that it's probably true, maybe you've done some investigation, you decided, okay, it's probably true that they're owed the money. And this is really true about all debts. So this is true about wage debts, but these three ways apply to collecting all debts, I think. So the most obvious one that most people think of, but is really the least effective, I think, is to scare the debtor, right? That's kind of like the strong arm tactic. That's what you imagine the mafia doing. They're going to scare the debtor into paying, right? And in the government world and the advocacy world, people also, the first thing they think about is let's scare the debtor into paying. So they say, okay, we'll come up with criminal penalties. That'll really scare them. Then they'll have to pay, or we'll do treble or triple damages of 10 times, and that'll really make them have to pay. That'll be twice the amount of wages. And the truth is, in my experience, that doesn't help much. And the reason why is because the kind of people who are scared by that sort of thing are the kind of people who follow the law in the first place. So they're not your collections problems. Your collections problems are the people who are trying to figure out how much they can get away with, and they don't really care about the penalties you're putting out before them. In fact, I think that sometimes makes it less likely they'll pay. I won't go into why, but I do think it sometimes makes it less likely that they'll pay. So I think number one's not a very good way to do it. So that leaves number 2 and 3, which is to seize the assets of the income or the debtor. That, in my mind, is usually the best way to collect any debt. But we'll be talking more about that at the end of this presentation when we're talking about judgment enforcement. There are some ways to do that early in a case, and I'm going to talk a little bit about that, but I think that's really the most effective way. Combined with number 3, which is the third possible way that in the universe of debt collection that one can collect the debt, and that's getting someone else to pay. That's why you have like a cosigner on a car loan, right? That is a guarantor, a cosigner, somebody who agrees to pay if the person who's the original debtor for the car loan doesn't pay. And there are other types of, other versions of that, other flavors of getting someone else to pay. That is insurance, right? It's a very classic common way, and bonds, which are really a kind of form of insurance, which is essentially getting the insurance company to pay for a debt. Or, and this is really important in wage cases, and I want to go into a little depth on this, is trying to get somebody who should be responsible but is not obviously responsible under employment law for the debt in all cases. So people up the contracting chain, or the individual owners of a company, or successor businesses. So we can go to the next slide. So let me skip over this a little bit, but just quickly say, in California, we have some restitution funds and we have some bonds. So this is when we're talking about that third way to collect a debt, basically getting somebody else to pay. The restitution funds are things that are funds that the state has, pools of money that the state has that it gets from certain businesses having to register with the state, and it gives that to workers who are owed unpaid wages, who have no other way to collect. Bonds are really the same idea, honestly. And there are some cases where we make, in California, where we make employers post bonds in certain industries, and they're the same idea. It's just a sort of private form of insurance, while restitution fund is a public form of insurance, right? It's what you're doing with a bond is you're saying that the employer has to put up this surety, this bond, and the bond company will pay for the unpaid wages if the employer won't pay. While with the restitution fund, you're saying the employer has to pay into this public restitution fund, and if the employer won't pay, the restitution fund will pay. But fundamentally, it's kind of the same idea. And the key point about these are that if your case is you have no hope of collecting from your employer, the person is gone, they've vanished to Timbuktu, and they have no money and there's no assets, it's a different kind of case than if they do. In that case, from the very beginning, your only focus is going to be on finding a bond or a restitution fund, or basically somebody else who's going to pay. All right, we can go to the next slide. So I think this is sort of the more interesting one, is finding someone else to pay who's related to the business. And the idea is that they're people who should be responsible, even if they're not technically the employer. In California, we have a number of laws, and I'm not going to go into detail because I don't have much time here, but a number of new laws which were passed to a large extent because people in the Labor Commissioner's office in California said, hey, there's this collections problem, we need to deal with it. One of the big problems is that in industries like janitorial, the low-level contractors are just, they're three-person operations. They have no money. The owner of the company is low income. They're practically a worker themselves. It's crazy that we're getting decisions against these people who can't pay and don't really set the standards in the industry anyway. So over the last couple of years, the state has passed a number of laws that, in situations like that, create liability up the chain, so that the general contractor, or even the owner of the building might be liable for wages. So those become really important, because in cases like that, when you identify it early on that that's the issue, you realize you have to get to that person up the chain. You have to find liability for that person up the chain, or your case is just useless. It's not going to go anywhere. Individual owners, that is another source. Successor businesses, there are a number of laws in California that make car washes, janitorial, ag, and garment that make successor businesses, even if they're not owned by the same people, but they just sort of step in and take over the business, make them liable. Those can be useful in some cases. I won't talk about fraudulent conveyance, but but the idea is that if somebody does change the name of an asset or a business and they pass it over to somebody else, there are ways to go after them legally, and often that's stuff you want to identify right at the beginning of the case, not at the end, or right when that shady kind of passing or fraudulent conveyance of assets occurs. Okay, next slide. So seizing assets an income prejudgment. So generally, it's hard to do. So we'll talk about this mostly under judgment enforcement. You usually need a judgment to do it, but there are a couple places where you can do it. And there's a reason to do it early on if you can, if you think the defendant is insolvent. The big reason is that if you properly encumber the asset or seize it, you're protected in bankruptcy. Basically, the ways that you can do it, I'm not sure if I have do I have a slide on this? Next slide. Yeah, so basically the ways that you can do it that I know about are there's some prejudgment liens and attachments. I won't go into detail about what those are now. I think they're going to be talked about later. But liens are they're a way to protect your right to a property, like a mortgage or something. And there's mechanics liens, which I think every state has. It's an ancient idea, or a 200-year-old idea, that construction workers can have a lien on the property that they worked on, but it usually has to be gotten right at the beginning of the case. Like in California, it's 90 days after the wages were due. So if you miss that statute of limitations, the worker's out of luck, but it's super powerful if you can do it. Writs of attachment, which have to be done in court, but they're kind of a creditor's remedy where, and they can be used for wages as well, but because they're commercial debts. But the idea is that if somebody has a good case and the real problem is just going to be collecting it, then the creditor, while they are suing to prove that they're owed the money, while they're pursuing the wages, in the case of a worker's case, can grab onto the asset with a writ of attachment that acts kind of like a lien. In California, we had a new law that, again, because of all the problems that folks in California have dealt with over the years on this, that was just passed 2 years ago, that for repeat offenders allows an automatic lien. And the last thing I wanted to say is just for escrow claims, and this is a little bit technical, but I think it's worth keeping in mind. For bankruptcy and escrow claims, this idea that the worker is a creditor from the day they walk into your office, in fact, from the day they are not paid correctly, is really, really important, because under a lot of debtor-creditor law, not put aside your employment or labor code, under a lot of debtor-creditor law, that is literally true. The worker is a commercial creditor, whether or not they have a judgment. That's sort of in the parlance called reducing the claim to judgment or liquidating the debt, but they are a creditor. They're owed this money from the day they weren't paid correctly, and that means for things like when a business is being sold under the Uniform Commercial Code provisions, they can make a claim in escrow to get their wages back. And if that's happening, if there's that kind of thing going on, a business being sold or the business files bankruptcy, the last thing you want to do is wait until there's a judgment or you've decided that the debt is valid. Even if your agency can't do it, you want to tell the worker, hey, you should look at making your claim as a creditor right now, because the business is being sold or the bankruptcy, and all the money is going to be distributed. And by the time we decide the case, there'll be nothing there to get. So that's sort of the last place where you might grab money and assets at the very beginning of a case. And a lot of it has to do with seeing clearly that the workers are creditors from the day they're not paid the money. So.
Okay, so we should move on now to negotiations and hear from Cindy Mark. Next slide, please. Great. Cindy?
Hi, Janice. Hi, everyone. I'm going to talk about negotiations and what we've found in Massachusetts to be effective. So first question is, what are the useful tools in getting an employer to agree to a settlement? I mean, I think that the most effective negotiations are those that are well supported by law and fact, of course, and preparation is the key. So we're in a stronger position in negotiations if we have records, witnesses, and a complete audit. This is not always possible, but it's really important to focus on the strengths of your case. In the AG's office in Massachusetts, negotiations are handled by an investigator AAG team. We have two types of cases. We have like quick resolution cases where it's one worker and we're just trying to get the last paycheck or maybe the last two paychecks. And then we have company-wide systemic cases, which is what I'm going to focus on today. In terms of what terms of the, what terms are non-negotiable and what terms are negotiable, I'll start with the non-negotiable terms. So first of all, employers must be in compliance. Like, by the time we get to the table and start negotiating, we've already done things like payroll demand, interview of workers, interview of employers, And so the employer should definitely know by the time we get to the negotiating table what the violations are. They should already be in compliance, and if they're not, we're not going to settle with them. Employers also have to agree to pay full restitution. So it may be negotiable. What may be negotiable is how much is owed. Like, we may have a view of the facts and they may have a view of the facts, but based on what we have found, if we are confident that, you know, this is the restitution that's owed, we're not going to settle for less. And then the third thing that's really not negotiable is press. So some employers will say, we can't take bad press here. Like, we don't want any bad PR here, or we want to review the press release before it goes out. It's an office-wide policy that we do not negotiate press, and so that's just off the table. What we will negotiate are penalty, and maybe the time that they have to pay the restitution and penalty. So how long do we give employers to pay restitution and penalty? Ordinarily, we expect employers to pay within 6 months. Sometimes employers will say, we don't have enough money, like that's a really big amount of money you want us to pay, we need at least a year or more than a year. If an employer is asking for a year or more, then we're going to ask for income verification that are submitted under pains and penalties of perjury, and we're going to ask for tax returns for both the company and for the individuals who are responsible. The individuals who are responsible are the president and or treasurer of the corporation. And so we're asking for 2 to 3 years of tax records. Some employers who really have the ability to pay, but we're trying to buy more time, if we ask for all this documentation, they will frequently say, you know what, it's not worth the hassle. I'm just going to pay 100% upfront within a year or within 6 months. In some cases where we've agreed to a longer term, we have built in some incentives from, like, if we believe an employer really financially will have a hard time paying within a year, we'll agree to a longer term payment plan. But we may build in some incentives. So if they pay early, they will pay a lesser amount. Another question that I wanted to address was, how long do negotiations typically take? It's really hard to say what a typical negotiation is. We hope that negotiations will not take more than 2 months, 2 to 3 months, but some negotiations can take longer if we're arguing over the facts and records, and so that can take a while. I just wanted to share some successful examples of collaborative negotiations that we've done with the U.S. Department of Labor. And in the last year, we've resolved 2 major cases that started as joint investigations with U.S. DOL, and that resulted in, one was a little over $1 million and one was a little less than $1 million. So in those cases, we engaged in joint investigations, we both requested records, and we both did pretty substantial audits, collaborating all the way. So the state looked at minimum wage violations, and U.S. DOL looked at overtime violations. And sometimes we're waiting for them, sometimes they're waiting for us. But when we were ready, our audits were complete, and we had a good idea of what we thought the employer owed. We set up a meeting with the employer. These were joint employer cases, and so it was a client company and staffing agencies involved. meeting with the client company. And, you know, basically we invite the client company in, and I learned from USDOL, what they do is that they basically present the employer with a bill. They say, you know, we've done our audit and this is what you owe. And in our office, you know, we always demand that the employer pay liquidated damages. So if you owe $210,000 in overtime violations, we're asking you to pay $420,000 in overtime. And here's our standard settlement agreement. So you can have a week to look it over, but this is what it is. And so we've really followed USDOL's lead in that approach, and it's been very, very successful.
Okay, Cindy, that's great.
Okay.
Now is, I know there's so much more to say about all these topics, but I just want to make sure that we cover where we're going. So next slide, please. And Cindy, this is you again. If you could say a little bit about settlement agreements, and then we'll turn again to Sarah Lehrer. So Cindy,
Sure.
can you begin, please?
Sure. So we settle just a little more than half of our cases. And the advantage to settling cases quickly, of course, is that you get restitution for workers. You know, they're sure to get it. And for the employer, the benefit is that they'll get a lower penalty. When we settle cases, we, as I said, with negotiations, we always require compliance. So our settlement agreements always have some compliance measures and safeguards. I would just like to talk about some of what have been some novel settlement agreement provisions that we've entered into in the last year or so. You know, people should think creatively about settlement agreements because the parties can agree to virtually anything. You can demand things that you might not get from a court judgment. So some things that we have asked employers to agree to, and employers have agreed to in some joint employer cases like I was just talking about, are that employers will agree not to use staffing agencies, or they'll agree to limit their use of staffing agencies only if there's a surge in the workload that can't be performed by their regular employees. If a company uses a staffing agency, we may ask them to, we may have in our agreement that they will require the staffing agency, in their agreement with the staffing agency, to pay minimum wage and overtime, to maintain true and accurate payroll records and time records, to pay wages via payroll check with a pay stub, and to conduct a monthly audit of the staffing agency's payroll. We've also asked for client companies to maintain independent time records. And if the client company fails in policing their staffing agencies, in our settlement agreement, we have a provision that says that if they fail, they will be per se liable for any future wage and hour violations by the staffing agency. So those are just a few of the settlement provisions that we've looked for in Massachusetts.
Okay, so now we're going to turn, thanks Cindy. Now we're going to turn to Sarah Lehrer from the Office of Labor Standards in Seattle. And Sarah is going to actually do screen sharing, which we're praying is going to work. So Sarah.
Hi there. This is Sarah from the Office of Labor Standards. Let's see here. I'm trying to hit the screen sharing button. All right. Are you seeing it?
We're seeing your cat.
Okay, that's not my cat, but it's really cute. So I'm going to be talking about a couple of documents that are here. If everyone can see down under the handouts button, you can actually click and open from this meeting. I think they'll also be shared. But here is our standard settlement template, which we generally use kind of to begin, you know, so we don't have to draft from scratch. And it has all sorts of terms, and you just kind of cut out the ones that aren't needed. There's general terms, and then there's terms related to each of our laws that we enforce. And so I'm just going to go through some of the kind of more important terms that we have here. We always make them, except in very specific, limited circumstances, agree or at least acknowledge that there's been a violation and what number of violation in the ordinance. And that's important because we have penalties that go up from the first violation to the second violation and third violation and subsequent. And then down here, we also have...
Yeah, just remind people which handout when you say here, just remind people which handout you're looking at, okay?
Oh, sorry, it's the settlement template. Can you see this on my screen?
The one that says settlement terms?
No, just this one that says OLS settlement template .docx. Is it not coming up?
I can see it on the screen.
Okay, good.
Okay,
all right,
good.
Keep going.
Okay. So then here, the civil penalties and fines. I just wanted to call this out because this is an example of, in prior versions of our ordinances, we didn't have nearly all of these civil penalties and fines. And so there were certain things that would happen, like maybe they didn't maintain records correctly or whatever, and it was really hard to put a dollar value on what they should be paying for that. And so we went and amended our ordinances and included a bunch of fines for these things that were hard to assess damages for. So now those are in there. And again, relating to like the first violation, second violation, here's where that is. We also, this is going details of all the laws. I'm going to scroll down to paragraph 26. In almost every settlement agreement, we require proof of compliance within 30 days. And so these paragraphs will be changed based on, what the investigation concluded and what we need to see that they have actually complied with the settlement agreement. The investigator is generally responsible for ensuring that they do provide this proof of compliance within 30 days of the agreement. And then the next paragraph 27 is about compliance monitoring, which we'll talk about later in this webinar, and that's in almost every single settlement agreement. And then this one also is training for the employer. This is also in just about every single settlement agreement we have. Now we've also kind of like, as Cindy was saying, you can be creative. So we have some other settlement terms that we've used or are working on. And I'm now looking at the document called OLS_other settlement terms. So the first section is provisions that we've already used. In certain cases, we've had the employer implement a tip tracking policy that's transparent so that employees can understand why they're being paid, what they're being paid, and can actually ask for, let me see the calculations, let me see what I actually got. Rest break policy to ensure that the employer will actually, kind of take note when people have been on shift for a certain amount of time and just verbally tell them to take a break. Worker training, which is sort of similar to the employer training, but we have learned that a very important aspect to worker training is to say specifically that the employer and their representatives may not be present. That really changes the tone. And then we've done some payment plans. Again, for these cases where, kind of taking into account the business's assets and, ability to pay, and we really do try to kind of, we have an understanding that a lot of smaller businesses, immigrant-owned businesses, they're essential to our communities. They're essential parts of their communities. We want these businesses to succeed. And so in thinking about the payment plans and other things, we are also thinking about equity issues and what we're putting on the business. We know that some of these cases, people maybe are approaching business without like a real understanding of like all the regulation and workplace rights and responsibilities in the United States, and those are the cases that unfortunately you often see they screw up the worst. And then it's a small business, and then you're ordering that they pay like a year's worth of their receipts So, we do try to take those into account, and then that also gets to some of the provisions that we're working on. So just to skip down here to where it talks about business support consultation. This is something, a case that I'm working on with a small restaurant, immigrant-owned restaurant, where it's a real hardship to be paying all these back wages to workers. So we're trying to partner. We're working on a partnership now between a community business organization that we already partner with and the Seattle Office of Economic Development. And we were going to write into the settlement agreement that the business must agree to engage in a business consultation. And this community business organization will be able to provide like linguistically and culturally appropriate outreach, and they already have knowledge of our laws, as well as they're business people, so they know how to run businesses as well. So they're going to go and they're going to train this employer and also help them establish systems that will allow them to comply with our ordinances. And that's something that our office can fund. And then the Office of Economic Development has a service where they can conduct business needs assessments, and then they can follow up either within that office or kind of using other resources to try to figure out ways to meet those needs. Another
Sarah,
thing that we're working, yeah,
sorry,
go ahead.
Sarah, we have to skip ahead because we're a little behind. Would you mind just a little bit about the obstacles and enforceability, and then we should move ahead?
Let's see here. Well, I mean, the obstacles, I think, especially with these more creative things, have generally been just kind of moving through the bureaucracy of the city. And we enforce our settlement agreements usually just through contract theory, by sending it to, if there is, if they do breach the settlement or anything like that, we send it to our city attorney's office, and then they pursue it. It's our process. Is that what you were hoping for? Just sorry to be real fast about it.
Oh,
okay.
No, that's okay. I want to really encourage people to look at all of Sarah's handouts. All of the settlement agreements that they're playing with now are available. You can see the long list, and it's really exciting, including joint compliance monitoring with community organizations. So now if we can go to slide 16, please. We'll hear a little bit from Cindy, Mark again, and Matt Ciroli again about final judgment collection. So where we are now is on judgment collections. Yes, perfect. And if we could go to the next slide and hear from Cindy, that would be great. Cindy?
Sorry about that. This is all you need to know about our statutory authority is that under Mass law, the president and treasurer of a corporation are personally liable. So in all of our enforcement actions, citations, and settlement agreements, we will include the president and or treasurer as a responsible party. Next slide, please. When an employer fails to pay a citation after exhausting all appeals and the citation debt becomes a DOR debt, a Department of Revenue debt. And DOR, under our law, you'll see here that the interest rate is 18% per year. And if an employer doesn't pay, then DOR can put a lien on an employer's real property or social security number. Can you go to the next slide, please? These are all the things that DOR can do. And for us, it's great because we've issued the citation, we've defended it on appeal, and after the debt is due, DOR takes it from there. So they'll put a lien on the employer's real property. They can levy bank accounts. They are automating their system now so that if an employer doesn't pay, it can impact an employer's ability to to renew a license, to renew a car registration, and to otherwise seize assets. Next slide, please. We have been, one of the most frustrating things, and I think Matt started with this, is the most frustrating thing is when we issue a citation and we can't collect. It's frustrating for us and it's frustrating for the workers. And so we're looking beyond statutory bases to collect. We're looking at other partners, including licensing departments, cities and towns, and general contractors. So next slide, please. In cases involving restaurants and bars, the quickest way to get an employer to pay is to bring their case to the ABCC. And if an employer thinks that his liquor license is at risk, he will find money to pay. Next slide, please. Many cities and towns in Massachusetts are passing local wage theft ordinances. So in Massachusetts, Boston issued an executive order probably about 2 years ago. And so if it's a Boston-based business that has engaged in wage theft and hasn't paid, Boston can deny a license or a contract with employer, or Boston can require the employer to post a wage bond before entering into any contracts. And so these are all additional pressure points to encourage an employer to pay. Next slide, please. We also have been working very closely with some general contractors. So we don't have the same types of laws that California has, where you can go up the chain to get a general contractor or an owner of property responsible for paying a wage theft debt on behalf of workers. But we have been able to engage general contractors who want to do the right thing, we hope, to make sure that they ask their subcontractors or sub-subcontractors to submit payroll records and time records to the general contractor so that they can help us police the workforce to make sure that all workers are paid. Next slide. I just wanted to include my contact information and my colleague Lauren Moran's contact information if people have questions about our collections authority.
Okay, Cindy, that was fantastic. Thank you so much. We're going to move now to compliance monitoring, but before we do, let me just ask Matt if he has anything else he wants to throw in very quickly.
Sure. Let me throw in just two new strategies that California has been using to collect judgments. So after there is a wage judgment, these were both, again, in those sets of laws that I talked about that were passed recently because of all the problems that folks in the Labor Commissioner's office and advocates have seen with collections problems. And the two big changes are, for levies, we created a very simple levy system for the Labor Commissioner. The thing that you have to know, the background you have to know, is that traditionally the way levies are done, and this is going to be true in most states, is that it's a bunch of court paperwork and then the sheriff goes and physically takes property into possession. So for bank accounts and accounts receivable, money owed to the business from its customers, that doesn't make a lot of sense. It's kind of a waste of time to have to go through all of that. So this new law was passed that basically gives the Labor Commissioner the power to send a letter, a demand, to the bank or the customer of an employer and say, just pay us the money, we've levied on it. So that was one big change. And the other is stop orders. These take a lot of resources, but on some cases where they're particularly important, we're sending out deputies to actually shut down businesses because they have unpaid judgments. And yeah, so those are the two new strategies that we've been using.
Okay, wonderful. Okay, so now we are at the final presentation on compliance monitoring. It's back to Sarah Lira from Seattle. Sarah will just finish us up on compliance monitoring, and then we'll turn to your questions. Thanks, everybody, for your patience in waiting for us to get through our presentations before questions. But we're getting very close now, so I hope you are thinking about your questions and are ready to share some of them with us. Sarah?
Yeah, hi. So I am again trying to share the screen, but it doesn't seem to be working. So I don't know if there's something. Okay, here we go. Great, thank you. So I'm looking again back to this settlement template because I just want to preface the compliance monitoring by talking about this paragraph in our settlement agreement that talks about it. We do compliance monitoring in almost every single settlement, and it's just we sort of tailor it to the facts and circumstances. If the employer is less trustworthy or sort of needs more hand-holding, we would have more compliance monitoring. We're flexible on the duration, usually like 1 or 2 years. This one has like submitting documents twice a year for 2 years or until they no longer do business. In some circumstances where it seems like the employer just like got everything together and corrected the situation as soon as they found out that they were out of compliance, this might just give us the right to visit their place of business and review records and interview employees for a year, and we might not have this like requirement to submit documents. But when we do, then the paralegal is the one that does the compliance monitoring, and that often includes talking to workers, reviewing photographs of like notices and posters that are posted, requesting and reviewing records, obtaining a declaration that says they're doing everything right. And so here is the compliance monitoring template. So now I'm looking at the OLS compliance monitoring template document. This is something that we just use in the file to track, and it's helpful. You can put the language in here to kind of keep track of what they need to be doing, write down what each item or proof is needed, and then this is something we can actually send to the employers as well to help them track. Usually we'll work with the employer to correct minor issues. I mean, well, I should go back. Talking to the paralegal who does this, I understand that they generally find that about half of employers are not in compliance, like basically 6 months down the line or so when we do the compliance monitoring. So it's a huge number of non-compliance. And so usually they'll work with the employer to correct any minor issues. But sometimes, maybe they'll find that, oh yeah, like still like paying incorrectly, is continued or whatever. And so they may enter into a new settlement agreement if new damages are discovered. And then that settlement agreement would say that it's a second violation and would have, penalties at that level. And in some of the worst circumstances, we may have to open a new investigation. Usually the employers don't want another investigation, so they will agree to settle. Compliance monitoring is a significant time commitment, but it does seem to be more effective at changing employer practices. So, it can be anywhere from like an hour or two in the best of circumstances to, months in the worst.
So
That's all I have.
thank you so much, Sarah. Now we'd like to turn to your questions, and I'll turn over this portion of the agenda to Pranita Gupta.
Great, thanks so much. I know we have quite a few questions, so I'm going to start with a few questions that have already been written into the chat. But if you would like to ask a question, please just raise your hand and we'll unmute you so you can ask your question. So I'll start with the very first one. The first one is, does prejudgment interest fall in the non-negotiable or negotiable category?
Matt?
I don't think that was from my section of the presentation.
Okay.
I would negotiate it. So I guess in California we would negotiate it for sure. A lot of the negotiation can come down to economic realities sometimes, right? I'd rather get as much as I can than just sort of holding firm and saying we'd rather have zero than cut our amount at all. For most cases the workers don't want that either. So.
Cindy, did you want to?
Yeah, so
Sorry,
this is Cindy.
Oh, sorry, Cindy. I was just going to jump in and say in Seattle that they'd say we can't, due to our ordinances, we can't negotiate that.
And you get it. You can't negotiate it away, you mean?
Correct.
Yeah. In Massachusetts, we do not get prejudgment interest. So that's not something that we demand or get.
Okay. And I'll move along then to the next question. It's from James Rogers. James, we're unmuting you right now.
I mean, that has the most, this is the thing that's a bit of a minefield, because if I was the judge, I'd say, well, when did you decide that 813 was enough of a sample, and when did you decide that 813?
Okay, James, I think you started talking.
The second one is like a legitimate question, but and the answer is we decided it this year.
Sounds like that our conversation.
Okay, so I'm going to call on Bernice Casey. Bernice, are you ready? Bernice, you're unmuted. Hello, Bernice? Okay, so I'm going to read the question I think Bernice asked. I would like to hear more about how the labor offices were working with their sister agencies, like Office of Economic Development. Specifically, are labor offices and Office of Economic Development conducting site visits together to determine how to assist employers with compliance issues?
Hi, this is Sarah again. We are not conducting site visits together. I think that we sort of see the investigation as pretty different from the business support. The Office of Economic Development has their programs to assist small businesses, and so we're actually working on the first instance of collaboration right now and trying to navigate that bureaucracy. But the idea is that this will be put into place after the settlement agreement. We'll get them to agree in the settlement agreement to this business consultation. And we'll just see how this develops down the line. I know that our business, we sort of have a firewall in our office between the outreach folks and the investigation folks. And so our business liaisons may work with the Office of Economic Development in other ways to proactively prevent violations. But by the time we've found problems, we're going to wait until after settlement is done.
Great. So the next question I have is, if an employee wants to accept a lower amount in damages, would you allow this? I understand not the earned wages and penalties.
I mean, I'd say in California, it varies a little bit. If it's a citation that the state has put out there, we wouldn't necessarily take the workers, the workers' opinion into consideration, but there are a bunch of claims that the workers themselves bring, and in those cases, the workers can settle them for whatever they want to settle them for. So yeah, it can vary a little bit on whether it's the agency bringing the claim or the worker before the agency. So yeah.
And this is Cindy from Massachusetts, and that's the same for us. So if it's our citation and we found that a certain amount was owed and the worker is willing to accept less, we would take that into consideration, because if the matter's on appeal and it would take a long time to get through the appeals process, like if it's close and it's a reasoned compromise, then we would accept it, but not if it's just like, I need the money now and so I'll take 10%.
Great. So I have two questions from James Rogers. The first is, what states have laws requiring wage bonds? In New York, we have it only for nail salon or public works. And his second question is, what's up the chain customer mean?
So I give,
go ahead.
Yeah, some written answers, but I'd be interested in hearing if other states have wage bonds. In California, I didn't lay them out, I think, but we have them. All farm labor contractors, car washes, and construction contractors need to get bonds that cover, at least in some part, wages, and they have to be used on appeal. So if we issue a citation or there's an administrative decision that a worker is owed wages and the employer wants to take it to court, they have to post a bond to do that. So that's basically where we got it in California. for the first question.
This is Cindy, and I think that I'm the one who referenced up the chain. And so what I'm talking about is when you have a general contractor who hires subcontractors, who hires subcontractors, who hire subcontractors. And so the challenge is collecting money for those workers who work for the subcontractor. And sometimes you have to go up the chain to reach the general contractor to recover monies. We don't have a law like California that allows you to do that, but there's pending legislation. And even though there's not statutory authority, sometimes we've asked general contractors to take responsibility and to be a responsible general contractor, and sometimes they comply.
And it's worth pointing out there's old-fashioned ways to do this, even without the statutes. The biggest one is joint employer, and the idea is, and I think this would apply in most states, it certainly would apply under federal law, but the idea is that somebody who is a higher level contractor, even if they're not technically the employer, they're not on the paychecks, may actually act and behave like an employer, in which case they can be deemed the employer. So that's always worth looking at, even if you don't have any statutory up-the-chain liability.
Great. And so we have a question from Lawrence Griffin. When you have a claim from a single worker, do you investigate for all of the employees or just the single claimant?
Seattle investigates for all employees. And so then that also complicates matters if a single worker says they want less money, that they would accept less. We would actually make that person opt out of our settlement and collect it another way.
This is Cindy, and in Massachusetts, we have the discretion to go after the damages, the wages for the single worker, or to open up a company-wide audit.
Yeah, and in California, it's kind of the same. It depends a little bit on what track the case comes to us in. If it's a citation where we are doing the investigation, it would usually be for all the workers. If it's a case where the worker came and filed a claim and we have this kind of administrative wage claim process, then it wouldn't be for all workers. It's basically whoever filed the claim.
Great, thank you. The very last question I have is from Sally Dwarak Fisher. Sally, can you unmute yourself? Sally? Okay, I think we're having technical difficulties with the last question, so I think that's it. Thank you so much for joining us on today's call, and thank you to the presenters. Janice?
Yes, so we would just like to say to all of you that we will be sending you out contact information. We're also going to send you out handouts and slides, in particular from Matt Ciroli, who has a whole big bunch of slides that we think you will find very useful. We'd also love your suggestions about ideas for future webinars, and also your suggestions for how to improve these webinars. We thank you so much for joining us, and we'd like to stick to our 1 hour limit, so we hope you have a good afternoon, and thanks so much for joining us. Goodbye.